Oral arguments were held today at the Supreme Court in two related cases brought by commercial fishing companies who are objecting to the enforcement of a regulation requiring them to help fund the conservation and management of coastal fisheries. While the stakes of the fishing cases might sound small or narrow in some ways on paper, the consequences of the Supreme Court's decision could be massive. The justices are effectively considering whether to overturn the 1984 ruling in the case of Chevron versus Natural Resources Defense Council, which forces judges to defer to federal agencies when interpreting federal statutes and would impact regulations in nearly every sector. During 3.5-hour oral arguments today, Solicitor General Elizabeth Prelogar told the justices this.
Congress, agencies, states, regulated parties, and the American public have all relied on Chevron and the regulations upheld under it to make important decisions that could be upended by overruling that framework.
You say don't overrule Chevron because it would be a shock to the system. But the reality of how this works is Chevron itself ushers in shocks to the system every 4 or 8 years when a new administration comes in.
Justice Ketanji Brown Jackson expressed concern that overturning Chevron would lead the courts to taking over as the policymakers.
At the end of the day, I think the way I've been thinking about Chevron is Congress has given that policy choice to the agency. And my concern is that if we take away something like Chevron, the court will then suddenly become a policymaker.
The New York Times reports the lawyers who represent the New Jersey-based fishermen are working pro bono and belong to a public interest law firm, Cause of Action, that discloses no donors and reports having no employees. However, court records show that the lawyers work for Americans for Prosperity, a group funded by Mr. Koch, chairman of Koch Industries, and the champion of anti-regulatory causes. Joining us now is Democratic Senator Sheldon Whitehouse of Rhode Island, a member of the Senate Judiciary Committee. He is also the host of the podcast, Making the Case. Senator Whitehouse, there's no stronger supporter of commercial fishing in the Senate than you are. This case, it seems as though it has a lot more than fishing at stake.
Yeah, there's something fishy about that. These New Jersey fishermen are perfectly appealing. I tend to agree with them that the monitors should come off the boats and that technology should replace the human monitors. But that's not what this case is about. The apparatus that wants to undo the American regulatory system has poured into this case, with the lawyers for the petitioners, for the fishermen, working for Koch, the Koch Industries groups, and with a flotilla of phony front groups that all turned up to file amicus curiae briefs in the court. I spend, I think, more than 10 pages of my brief going through all the interconnections of these various amici with each other, with right-wing funders, with the Koch brothers' political operation, and sort of lay out the case for how behind these nice fishermen is this enormous armada of influence cooked up and funded by these right-wing billionaires who, not coincidentally, were also behind putting right-wing justices on the court to give them the rulings that they're now asking for.
The reason I really wanted to focus on this tonight is that it's easy to focus on the really big things in the United States Supreme Court, the abortion issues that come to the court. But this is the kind of day-to-day way in which the United States Supreme Court can have this country take a turn that most people won't notice.
Yeah, people don't know what the Chevron doctrine is. You can stop somebody on the street and say, hey, what's the Chevron doctrine? And unless they're a very particular kind of lawyer, they won't know. But what it is the doctrine that lets America's regulatory agencies make the decisions where they have expertise. And it's really important when you're up against big industries that have a lot of experts to have experts against them who can call BS on them, who can call their bluffs, who understand the complexities and don't get fooled. And what these industries want to do is they want to shut down the regulatory piece of that and move so that they can make their arguments to courts, which are not expert, which are much more easily fooled, and which, if you pick the right judge, are on the side of the big industries now anyway, after all of the Federalist Society's work packing various courts.
And one of the things we've grown accustomed to hearing from the Republican judges on the Supreme Court is that Congress hasn't specifically authorized X or Y. Congress has very specifically authorized what is at issue here.
Yeah, there is so much of the argument against the Chevron doctrine and against administrative regulations that is just complete hogwash. For instance, they say that it's completely unaccountable and therefore not part of our proper separation of powers. And yet the piece you just read from Justice Kavanaugh was him saying, actually, it changes every 4 to 8 years, right? Responsive to the public. And Congress, our appropriations committees go over these agencies every single year. And we've got the Congressional Review Act to respond immediately if they get out of line. So they're super accountable. They're very responsive to the political pressures that are around them, but they do it from a position of honesty and integrity and expertise. And that is what the polluting industries can't bear.
It sounded like the Republican judges on the court were ready to get rid of this principle completely.
Well, it'll be interesting because they shot a major torpedo into the American regulatory system back in the West Virginia versus EPA case by creating something called the major questions doctrine. Remember, too big to fail? This is too big to regulate. That would have to go back to Congress. So this Chevron doctrine overlays with the major questions doctrine, and it wouldn't surprise me if they were a little bit chastened and hung back a little bit on taking too big of a bite out of the Chevron doctrine, A, because it's nonsense, and B, because they can do so much of the damage that their backers have put them onto the court to do using the major questions doctrine. They don't need to undo Chevron to do a lot of damage to the American regulatory system.
Senator Sheldon Whitehouse, exactly who we needed to talk to about this tonight. Thank you very much for joining us.
Thank you, sir.
Thank you.